So welcome everyone to Elder Abuse Prevention Ontario's webinar series. We're pleased to host another series of webinars. We've been doing many since the beginning of COVID. Unfortunately, not being able to do our in-person, we've been offering a lot of opportunities for people to receive education around some important issues that are very timely and important for older adults as well as caregivers and our stakeholders that are caring for older adults in our community. So today we're hosting a session on balancing seniors' rights, preventing abuse by attorney acting under a power of attorney document. And I'm so pleased to work again with our WELL partners today to host this session, who are going to bring their expertise to the webinar to share their wealth of knowledge with dealing with elder abuse as well as powers of attorney with us. Just before we get going, I do want to give a few housekeeping details that people have already been asking for. All attendees will be muted as well as their videos will be turned off during the session today. We have two ASL interpreters who have joined us today, and their videos will be shown as well as our speakers during the session. The speakers will be visible right now, but the only speaker that will be showed is the one who is actually speaking at the time. At the very end, when we do our Q&A session, we will show everyone's video so you can see the speakers when you want to ask them their question. Our ASL interpreters, there will be two. As you can see, there's 6 boxes of video. You can adjust the screen to make them larger by pulling across the line to make the speakers larger, or at the very top, there is an option about adjusting the screens on your own computers to make the speakers visible on your end. If you're experiencing a question, if you have a question, please put it in the question and answer box. That will be addressed at the end of the session. If you have a question, a short little chat thing that you want to ask that's not related specifically to the speakers, you can put that into the chat box, or if you want to speak with someone that you see as on the attendee list that you've seen, haven't seen in a while, you can have chats back and forth. Totally up to you, because I know these are opportunities to connect with people as well. But put those in the chat box as opposed to the Q&A box. That would be greatly appreciated. The one thing that we are going to do at the end with our ASL interpreter is that if you would like to ask a question to the interpreter in ASL, I would like you to, if you wouldn't mind, put that in the chat box saying you'd like to ask a question in ASL. That time I will then promote you to be a presenter or a panelist. You will then be able to show your video, sign your question to the interpreter, and they will then provide the response to you in ASL, and our speakers will give the response back. After the question has been answered, we'll then ask you to turn off your video and then promote you back to be an attendee. The last thing is that we will be doing an evaluation. You'll get a short pop-up little menu after the session to do an evaluation. There's only about 5 or 6 questions. Your feedback is really important. It gives us information about how we did, information about what resources or information you'd like to see in the future, and it helps us plan our future webinars. The contact information for the speakers will be posted at the end, and we are recording this session, so it will be posted on our website for future reference, and I believe WELL Partners will also be posting it on their website so people can access it as well. So I do want to thank our interpreter service, the SLIO, for providing our services today. And also I want to thank Maggie Doherty Gilbert from the Durham Deaf Services for her support in helping us promote our webinars as well to the community. So we are going to cover a lot of material today in the time that we have. So I'm not going to go through this entire list because I know that our speakers will be giving an overview of all the issues that they're going to be talking about around powers of attorney. But we really are going to get into some basic understanding, some of the frauds and scams that we are seeing out there, but really get into the logistics and the nitty-gritty about powers of attorney and understanding those and how they work within the legal system. So just a little bit about our organization before we start the webinar with our speakers. Elder Abuse Ontario, for those who aren't familiar with or haven't joined our sessions in the past, we are a nonprofit organization, have been established in 2002. And really our vision is to make sure seniors have a strong voice, feel safe and respected, and are live free from abuse. And we do that through coordinating of services, training and education and outreach. We are funded through the Ministry of Seniors and Accessibility, and our mandate is to implement Ontario strategy to combat elder abuse, which includes 3 main priority areas, which is, as I mentioned, coordinating services, training, and public education and awareness. So we continue to do that, our work within those capacities, and has grown since the inception of the strategy. And we probably have worked with many of you in various capacities over the years. So we are pleased that you're able to join us today to learn a little bit more around powers of attorney. So I'd like to introduce our speakers today. Firstly, I'd like to introduce Kimberly Whaley. She is a founding partner of Well Partners, which is a litigation firm in Toronto, practicing throughout Ontario and repeatedly ranked by the Canadian Lawyer as one of the top 5 and 10 boutique trust and estate firms. She's been practicing in the area of estate trust, fiduciary litigation, including power of attorney disputes, fiduciary accounting applications, guardianship applications for dependent support, and elder law. I've worked with Kim on a number of occasions, and I'm so pleased that she's able to join us today and share her wealth of knowledge with us. She's joined today with her partner, Daniel Pepperny. And Daniel he joined Well Partners as an associate lawyer in September 2018. Prior to joining Well Partners, Daniel practiced estate litigation at a large firm in Vancouver, BC, where he practiced estate litigation, commercial litigation, and insurance litigation. He's also appeared at the BC Supreme Court and the BC Court of Appeal and the BC Provincial Court. So I'm pleased that you're able to join us today, and I'm going to turn the mic now over to Kimberly.
Good afternoon, everyone. Thank you, Leanne, for the introduction and the kind words, and thank you to Elder Abuse Prevention Ontario for providing this forum to address some very important issues revolving around elder abuse, elder law, the misuse of powers of attorney. In our practice, Daniel and I see these issues quite frequently, and forums such as this are really important to disseminate knowledge and information. So thank you so much. We're going to cover a bit of ground today, as Rianne pointed out. We're going to do a bit of an overview of elder law, first contextually given our demographics. We're going to address a bit on powers of attorney, on guardianships, on scams and frauds, some issues particular to COVID-19 pandemic, and then we're going to answer your questions. So let's get started. Contextually, our population is aging and doing so rapidly. Globally, we're facing the largest demographic shift we have ever seen. There are an estimated 962 million people aged 60 and over, and that is growing at a rate of 3% annually. According to our Statistics Canada, between 2011 and 2016, which was the last census, Canada registered the largest increase in the proportion of seniors since Confederation. In 2016, for the first time ever, the number of seniors exceeded the number of children born, and it's estimated that there will be 12 million seniors by 2061. With longevity can come an increase in medical issues affecting cognitive ability, capacity, as well as related diseases and disorders that may affect capacity, and increase in individuals' susceptibility to becoming vulnerable and dependent, and therefore susceptible to abuse. 1 in 11 Canadians over the age of 65 currently has Alzheimer's or a related dementia. In Canada, dementia affects 20% of seniors by the age of 80 and 40% by the age of 90. And with the COVID-19 pandemic, there has been an increase in elder abuse across the communities, with an increased pressure upon families moving homes, many of whom have lost their jobs, and turning to elderly parents for support, whether that be financial or others, and leaving more seniors susceptible to abuse. So elder abuse can take on many forms. It could be financial abuse, physical, psychological, sexual, it can be neglect. And according to our Department of Justice, financial abuse is the most commonly reported type of abuse against seniors. And importantly too, that department also indicates that it's difficult to actually estimate the prevalence and incidence of elder abuse because of underreporting. Our World Health Organization, as you can see on the PowerPoint, defines elder abuse as a single or repeated act or lack of appropriate action occurring within any relationship where there is an expectation of trust which causes harm or distress to the older person. So what are some examples of elder abuse? We see prevalently the misuse of power of attorney documents for property, and we'll get into that more in a little bit. Stealing of an older adult's money, pension checks, possessions, committing fraud or forgery or extortion, sharing an older adult's home without paying a fair share of expenses, paying rent, paying for food, etc. Unduly pressuring or manipulating or influencing an older adult to sell personal property, to invest or take out money, to buy alcohol or drugs, to make changes to power of attorney documents or wills, to sign legal documents that are not really understood, to give money to relatives or caregivers or friends, to engage in paid work even, to bring extra money in that may not be needed for the person, but rather for those seeking to abuse. Domestic abuse, physical, mental, or sexual abuse. At predatory marriages, what is that? That's where an abuser marries an older adult purely for financial gain. An adult child who threatens an older adult parent, preventing access, for example, to grandchildren, unless money is lent or given, or living with them, or guaranteeing loans or mortgages, all forms of financial, psychological, and abuse and influence. Also, failure to provide the necessaries of life, whether that be under a power of attorney for personal care or otherwise generally. Living with an older adult and failure to pull their weight is a big one. So often financial abuse is perpetrated at the hands of a family member who the older adult is dependent upon and who has influence over or control over the older adult victim. Adult children who harm their parents may not do so intentionally, but may they themselves have various health or mental health disorders, substance abuse, social isolation issues, employment issues, or has somehow become financially dependent on the older adult. The abuser may rationalize this abuse, thinking that they deserve the money because they are the older adult's child, for example. Financial abuse can also be inflicted by a caregiver, a service provider, a stranger, or another person in a position of power or trust. And some perpetrators are scammers. So according to the Canadian Anti-Fraud Centre, and I'm going to refer to that next as the CAFC, Canadians have been defrauded out of at least $1.2 million that we know of during COVID-19 because of related scams. Between March 6th and May 1st, the center has received 766 reports, and with 188 of those fraud attempts actually succeeded. And these are only the ones that we're hearing about, the ones that have been reported. And I'm sure there's many more and much more happening out there than we know about. So avoiding these scams, it's important to recognize that they're happening, firstly, and to try to assist older adults in identifying and making sure that they don't fall victim to these frauds. With more seniors being at home alone during the pandemic, they may look, these fraudsters, to the internet to get information, and having no one to share the COVID-19 journey with, some seniors may be more susceptible to these scams. Fraudsters are, they never stop reinventing ways to scam individuals and have managed to find ways to capitalize on the pandemic to seek to play upon fear and anxiety of older adults by impersonating government agencies in relation to various government assistance programs, as well as impersonating loan and financial service companies offering financial assistance, for example, through cleaning or heating company scams. Offering duct cleaning services is a big one right now. It's actually been here for a while, but it continues. Impersonation of local and provincial hydroelectrical power companies threatening to disconnect services or power through non-payment. False representation of Centers for Disease Control and Prevention or the World Health Organization, even in offering fake lists for sale of COVID-19 infected people in your neighborhood. Some other scams include impersonation of the Public Health Agency of Canada, giving false results saying that you have tested positive, for example, for COVID-19, or tricking you into confirming your health card and credit card numbers for a prescription. Impersonation of known charities offering free medical products, for example, masks for donation. Impersonating government departments sending out coronavirus-themed phishing emails. So phishing being they send out an email from a legitimate address, but it appears to be coming from a legitimate address, and then asking for help or personal information, and it's usually marked as urgent, so you don't have time to think about it. Tricking individuals into opening malicious and attachments that infect a computer or an iPad. Impersonating financial advisors, pressuring people to invest in hot new stocks related to the disease. For example, companies offering a vaccine, etc., or companies offering loans in respect of the shutdowns. The selling of fraudulent products that claim to treat or prevent the disease, or friends asking for financial aid alleging that they have the disease and they need funds to wire them, to send them through email, etc. And these people are quite sophisticated. They will go to great lengths to try and trick you and appear legitimate, and use high pressure sales techniques to force you to do things that you wouldn't ordinarily do or think about. So the message is, don't provide your personal information. Nothing is that urgent that you have to do something immediately. Wait, investigate afterwards, and try to get in contact with somebody who can assist you in determining whether or not it was a legitimate call. Also, visiting the Canadian Anti-Fraud Centre website regularly to check and keep up on the most recent frauds is also important. So with that, let's move to powers of attorney, because I understand this is a hot topic right now. A power of attorney document is generally viewed as a way in which a person, any person, doesn't matter if you're young or old, can grant the authority to a trusted person to act for them during periods of incapacity, whether that be temporary or permanent, and or to act as agent to carry out certain requests. And that's a power of attorney for property, personal care, or general power of attorney, and I'm going to come to the different sorts in a moment. In our practice, unfortunately and very sadly, we see these power of attorney documents being abused regularly. While they can form an important part of a person's planning, because then the person has the opportunity to actually plan, well capable, and appoint a trusted person, sometimes it just doesn't work out. And that's not to say that you shouldn't do one. I believe firmly that you ought to do one, because if you don't do one, then perhaps you're more exposed, and we'll come to that. So in certain circumstances, powers of attorney, however, may cause rather than prevent conflict. It's important to know that a power of attorney is only in effect while a person is alive, and as long as the document has not been revoked. It is not valid after death. So before we discuss the different types, I'm going to give you an overview of the Ontario regime. Each province in Canada has a power of attorney regime through their own statutes or legislation. In Ontario, we have three types of powers of attorney. One, a general power of attorney. This general power of attorney is used through the Powers of Attorney Act, and it's usually for just a short term or a fixed time, often for a limited purpose. For example, simply to sell a piece of property, or because you're going out of the country for a month and it's just current during that event. It does not remain valid if a person becomes incapable, and that's a different type of power of attorney, and that is the next in the list there on the PowerPoint, which is the continuing power of attorney for property. So it's used to make sure that a grantor, so the grantor is the person giving the power, the grantor's financial affairs are looked after when the grantor is unable to do so. And that can be temporarily or permanently, should a person permanently lose the ability to manage their own property. So under the law, what makes a power of attorney a continuing power is if the document itself is called a continuing power of attorney for property, or it expressly names or mentions the intention that the authority is to be given and exercised during a subsequent period of incapacity. So importantly though, when a person decides to grant a power of attorney for property, you need to be capable of doing so. And that holds true for revoking a power as well. And the legislation, which is the Substitute Decisions Act, is the legislation that governs the granting of those documents. But as you will hear in a short while, not everybody has to go to a lawyer to do these power of attorney documents. And so the capacity to grant the power is not always assessed by a lawyer. Okay, so it's usually surprising to a person how much power is actually granted by these documents. They are a very powerful tool that permits the grantee, the person who is asked to assist, power to do anything with your property except make a will. Anything. So sell a property, use the proceeds, access bank accounts, access GICs, RSPs, RIFs, investments, everything. So, and importantly, the continuing power of attorney for property is effective immediately. So the moment you sign it, it's not always that the person who grants the power gives the power of attorney document over immediately, and so therefore there's some control over that. Unless the document has a triggering clause in it, and I'll explain that in a moment, it is effective immediately. So a triggering clause is something in the document which would say, this document doesn't come into effect unless, and there's a condition attached to it. It can be any condition. For example, it doesn't come into effect until I am determined to be incapable of managing my property by a capacity assessor or some such thing. In that case, there should be a mechanism in the document to determine that condition. And if there isn't, the legislation, the Substitute Decisions Act, provides some guidance. So the third type of power of attorney is one for personal care, and it allows a person who is capable to appoint another to make personal care decisions in the event of incapacity. So before we continue further with those power of attorney documents, let's talk a bit about what capacity is. So at law, every individual is presumptively determined to be capable. Individuals need to have the requisite capacity to make certain decisions or undertake certain tasks. So, for example, if you were seeing a lawyer, you would need the requisite capacity to instruct counsel. If seeing a health practitioner, you would need the requisite capacity to make healthcare decisions and consent to treatment. There's no single legal definition of capacity, and there's no general test or application for establishing mental capacity. Each decision or task has its own corresponding capacity characteristics and determining criteria or factors. As I said, there's a presumption at law that everybody is capable of making decisions unless legally rebutted. So how is capacity determined? Capacity is determined on questions or factors of mixed law, fact, and medicine, and by applying the evidence available to the decision and the corresponding criteria. And so you can already see that these capacity determinations can be complicated. They can be very complex. So capacity is decision specific. What is it that the person is trying to do? Is the person trying to grant a power of attorney, to do a will, to marry, to make a gift? So you can see that there are different types of decisions which require different types of factors to be applied to assess requisite capacity. It's time specific. For example, if I want to make a will today, then the question of my capacity to do so is today. Not yesterday, not next week, but today. Capacity is situation specific. In different circumstances, different people feel comfortable or stressed or anxiety ridden in different situations. For example, going to a lawyer's office may cause stress for certain individuals that they wouldn't otherwise feel if at home. So you want to look at the context within which instructions are given or situations are made. Generally speaking, capacity to make a decision is demonstrated by a person's ability to understand all the information relevant to the decision and then to understand the consequences of that decision. Importantly, capacity is not equated with the standard of correctness or reasonableness. So we're entitled to make foolish decisions. It doesn't mean that we're incapable. It means that all of us have a different idea about the things that we want to do. According to the Substitute Decisions Act, Section 8, a person is considered capable of granting or revoking a continuing power of attorney for property if having knowledge of their property, awareness of their obligations owed to dependents, knows that the attorney will make decisions that will affect them and that the attorney must account, and that they can revoke the power if at some point they're unhappy with the appointed person, Appreciate that unless the attorney manages the property prudently, it may decline, it may be depleted, and appreciate the possibility that the attorney could misuse the power. So that is a test, so to speak, or the criteria under statute for actually granting. Remember, I said that you don't actually need to go to a lawyer to have these documents done. And so, because you can print them off the internet, often we see would-be predators printing them off the internet, taking them to an individual, making them sign, as long as it's compliant with the witnessing obligations. On the face of it, it looks like a valid document, but it might not be, because the person might not have had the capacity to grant or revoke. So now let's move to capacity to manage property. Appreciate I told you that capacity is decision specific, and there are different factors to apply. With respect to the capacity to manage property, the Substitute Decisions Act again assists us, and it's section 6, and it says that we assess this on the ability to understand the information that is relevant to making a decision in the management of one's own property, and the ability to appreciate the reasonably foreseeable consequences of a decision or a lack of decision to do anything at all. An attorney under a power of attorney for personal care is not a care provider, but a decision maker, and section 47 of that same legislation sets out the criteria for granting or revoking a power of attorney for personal care. Again, a different decision with different criteria applied. Importantly so, the point of all of this is for you to know that just because a person doesn't have the capacity to manage their property doesn't mean that they don't have the capacity to grant a power of attorney for property or for personal care. So for the criteria for appointing a personal care attorney, one would have to understand whether the proposed attorney has a genuine concern for the person's welfare, and appreciate the person may need to have the proposed attorney make personal care decisions. What are personal care decisions? Well, the statute also helps us with that, and it includes health care, nutrition, shelter, clothing, hygiene, safety. So this is actually the next PowerPoint along, and you'll see that it's listed there when the PowerPoint comes up. And the criteria to determine if an individual has the requisite capacity to make personal care decisions can be found in section 45. And again, it's the ability to understand information relevant to those decisions and to appreciate the reasonably foreseeable consequences of the decision or lack of a decision. So importantly too, although it doesn't say it in the Substitute Decisions Act, treatment decisions are also made by attorneys for personal care. So where if you were in a hospital and you were meant to undergo emergency surgery and you could not give instructions to a doctor or consent to a doctor, the doctor would be looking for your substitute decision maker, which could be an attorney. It could be a multitude of other persons, but it could be an attorney for personal care. So let's now move to executing these documents validly in wills. And know that sections 10 and 48 of that same legislation require that these documents be executed in the presence of two witnesses at the same time, and who shall sign the power of attorney as witnesses. So all three people are together in the same place at the same time, and the only exception to that is one I'm going to speak to in a few minutes, and it only applies during the COVID pandemic. So the legislation also lists the individuals who cannot witness the document, such as the attorney's spouse or partner, the grantor's spouse or partner, a child of the grantor, a person who is less than 18 years of age. And The Succession Law Reform Act, which is a different statute, has a similar provision for the execution of wills. So in that legislation, Section 4, subject to the exceptions, that's sections 5 and 6, a will is not valid unless at its end it's signed by the testator, who's the person doing the will, or by some other person in his or her presence at his or her direction, and the testator makes or acknowledges the signature in the presence of 2 or more attesting witnesses present at the same time, and they would have to subscribe the will in the presence of the testator. So Section 12 of that legislation, the Succession Law Reform Act, further states that a will attested by a person to whom or to whose then spouse a beneficial divisee, bequest, or other disposition is given, the devise or bequest is void so far only as it concerns the person attesting, i.e. the spouse or a person claiming under either of them, unless a court is satisfied that the person attesting has not exercised any improper or undue influence. Okay, so how does one execute a valid power of attorney or will during the pandemic, during social distancing? There is a temporary emergency order in council made by the Ontario Attorney General. This was done on April 7th, and it allows for audio-visual communication technologies, such as we're using today, to be used to witness both wills and powers of attorney. One of the requirements is that at least one witness, however, needs to be a licensee of the Law Society, either a lawyer or a paralegal. The relief is temporary. Importantly, it only lasts for the duration of the emergency order, and then it will come to an end. And it's best to have these documents probably re-executed post-pandemic. The relief is not retroactive, and the powers of attorney and the wills that were signed before April 7th, if not compliant with the statute, are not valid. So they would need to be re-executed. On April 22nd, there was a further emergency order, and it amended the original order to accept execution in counterparts, meaning on separate documents. The attestation clause should state that the testator, the grantor of the power of attorney document, signed the document in the presence of both witnesses by audio-visual communication technology, and importantly, that one of the witnesses is a licensee of the Law Society. And again, if done in counterpart, it should also be noted that way. Affidavits of execution are also prepared for both by the lawyer witnessing the will and the power of attorney, and individuals, especially older adults, are encouraged to seek legal advice when executing these documents to ensure proper execution. Our province does not have substantial compliance like other provinces. And so unless a document is compliant to the letter with the statutes, the documents done will not be deemed valid. So that's very important to know. And it is the lawyer's job to ensure that the grantor of the power of attorney has the required capacity to grant, etc., and all of those best practices that I spoke about under the legislation must be followed. So our firm has prepared a checklist for lawyers checking on factors such as undue influence. As you can imagine, in a period of time where we're doing these virtual, digital, video, or telephone meetings and such, you want to make sure that one of these factors that come into play a lot in the predation of older adults is this undue influence, and to prevent it from happening. So undue influence is coercion. I will give you an example. Unless you give me $200,000, Mom, I'm going to put you in a long-term care facility, even though I know you don't want to go. But if you give me that $200,000, I'll look after you at home. That is undue influence. It's not just a pressure, it's a threat. So if you are doing a virtual meeting, you want to look at things like, is there an individual with the client in the same room during the video conference? I have actually seen this situation where I have asked the client a question and I hear a voice in the background and the client will say, well, just a minute. What did you say? And then the answer has been given by another person. Try and interview the client alone. Ask if there's anyone else. Try and get a 360-degree view of the room based on, if it's on a phone, have the client turn the phone around so you know who's in the room. And make sure the door is closed so that nobody can overhear. And observe body language and, observe whether or not the client is reading from something or whether notes have been passed to the person. What is the relationship between the client, the individual, and the individual who either brought the client to you or who may have been in the room before you asked that individual to leave? Who is your client living with during the pandemic? How is your client dressed? Does it raise any red flags about personal care? Is your client looking at the camera or looking to someone for answers or not really paying attention to you? Is someone writing down or holding up written answers? You want to know that. To prevent abuse by an attorney acting under a power of attorney document, financial institutions will want to see the original power of attorney document. And even though they want to see the original, it's important that they don't keep the original. You can obtain certified copies of an original from a lawyer who's able to say, I saw the original, I'm provided a certified copy under seal so that you can use that with a bank or other financial institutions so that they have a certified copy if necessary. Temporary acceptance of electronic copies will depend on the relationship between the individual and the entity which they are trying to get to rely on it. So, for example, a bank, an investment advisor, a long-term care facility, and how comfortable that third party is with the arrangement. Each case is determined on its own unique facts, and you can't really blame. I will say that you want to exercise some patience with these third parties. In an era of increased elder abuse and fraud, and particularly during the pandemic, that they may not act as quickly as you would like, but know that they are trying to act in your best interest to make sure you're protected. And knowing that these issues are out there and there are a lot of them should assist you in trying to be a little more patient with any institution who may be taking a little bit of time to make sure they're comfortable to rely on your power of attorney document. So for individuals who don't have power of attorney documents and are thinking of executing them, it is possible to contact a lawyer. Know that legal services are essential services during the pandemic. And you may, if you have a level of comfort or you deal with a financial institution who have financial advisors, consult with them for a recommendation as to who may assist in terms of a lawyer. Also that financial institutions may take a bit of time more than usual in trying to figure out whether or not they're prepared to rely on documents that are done during COVID and have been done electronically. They for sure will be looking for things like the affidavit of execution and to make sure that they're compliant with the emergency order in council. So factors to consider when appointing an attorney. Importantly, remember, trust the person you want to appoint. Trust them. If you can't trust them, if there's any doubt in your mind that they may not act properly, or they may have issues with siblings, or that they may not be financially set themselves, don't give them the opportunity to abuse your property. Know that this misuse and abuse is very prevalent. It's not a one-off. There's a lot of it. And while you may think that your child is the best person to be your attorney, really think it through. What are their circumstances? Are they managing their own property well? Are they going? If you choose one of your children over 5 other of your children, is that one going to be able to get along with the others and withstand scrutiny of the others when put in that position of power and trust? Discuss these issues with your families if you do choose to appoint one child or 2 children over many of them. Make sure they understand what your wishes are and why you've chosen one or the other, and what your wants and needs are, so that you put that fiduciary in a position of scrutiny, that they are able to withstand the scrutiny, because the other kids have heard it from you directly that this is what you want. Fights over property management and the use and depletion of family wealth, children arguing over the division of potential parental assets before and after death, unequal gifting, loans are more commonplace now. So maybe your attorney should be a professional. Maybe it should be a trust officer from a trust company, or a lawyer, or another professional who's in the business of providing professional services. Or maybe you choose that entity with one of your children, so there's a check and balance system. Whatever you choose is going to be unique to you, but make sure, at least from the get-go, that you think there's a shot that it's going to be used properly and carried out properly. And talk to the person that you want to have act for you, and make sure they're willing to do the job. If you go to the trouble of appointing the attorney, and then when it becomes necessary to use it, the attorney says, I don't want the job, I'm renouncing, and you don't have the capacity to do a new one, then you're stuck, and you're probably stuck with a guardianship order, which can be a costly court appointment. Otherwise, the public guardian and trustee may come into play, and that's obviously not who you may have chosen to manage your affairs. And again, can you trust the person not to misuse your property? And don't think that this is a document that requires equal treatment. In other words, I hear endlessly, I wanted to treat my children equally by giving them the power. That's not the criteria, because quite frankly, those children may not be able to work together properly, or one may have a substance abuse problem and be more prone to taking money to satisfy that substance abuse problem. So think it through. With that said, you've heard a lot from me. I'm going to turn it over to my colleague Daniel, who's going to continue and talk about some of the court decisions to illustrate to you some of the problems that we're seeing.
Okay, well, thanks, Kim. Hi, everybody. My name's Daniel Paperny. I'm a lawyer at Whaley Estate Litigation. I work with Kim. Thanks to everyone who's tuning in today, and I hope that you're all staying well and staying safe during these very odd and strange times of COVID-19. I was talking to Kim actually before we got on the webinar, and we both agreed that this topic that we're addressing today of elder abuse and preventing elder abuse and how to address it and remedy it has really never been more important. As Kim mentioned, we've actually seen a rise in elder abuse cases since the COVID crisis began. And as everybody knows, this is a pandemic that has disproportionately and tragically affected our elder population. I believe it's something staggering, like approximately 80% of all COVID-related deaths have come from senior care facilities around Canada, which is obviously a very troubling and tragic statistic. But it really hammers home the point that Kim and I hope that the listeners come away from today's webinar with, which is that it's crucially important for our elder community to have the proper planning tools in place, such as naming appropriate people as their powers of attorney, so that when they are vulnerable and at risk, there's appropriate mechanisms and tools and protective measures in place so that abuse does not take place and that our elder population is properly protected. The power of attorney tool can be a very powerful one and a very useful one for our elder population, because it appoints someone who can manage both the property and care of the grantor of the power of attorney when they may be incapable of doing so themselves. But as you'll see from some of these examples that I'm about to go through, it can also be a very dangerous tool, because the power of attorney grants a very broad discretionary power to the attorney that could use it to abuse financially the grantor of the attorney. So to start, I'm going to highlight a case or two that speaks to the dangers of granting a power of attorney and the importance, as Kim was mentioning as she was finishing her comments, that the person who you appoint as your attorney is someone who you trust wholeheartedly and is someone who you know will be able to act in your best interests as your fiduciary. So this first case that I'd like to talk about is a 2013 Ontario court decision of McMaster and McMaster. We like to call it the go-karts for mother case. But it's actually quite a sad circumstance. In this case, the grantor of the power of attorney appointed her two sons jointly as attorneys, but for whatever reason, she failed to notify one of the sons that he was appointed, and at first instance only told one of her sons that he was acting as her attorney. And the son that knew that he was the attorney for the mother had access to all of her assets and more or less exhausted her entire life savings to invest in rather dubious business ventures. So, for example, he decided it would be a good idea to use his mother's hard-earned money to invest in a go-kart business. And by the time that the other son, who was named as power of attorney, found out what was going on, approximately $2 million worth of the mother's assets had been entirely depleted by her attorney, her son, who she had trusted with managing her financial affairs, but had turned around and had done the complete opposite of what he was supposed to do and had blown through all of her assets rather than protecting them and protecting her. So there was an application to court to have the son removed as the attorney, and the court granted that application, removed the improperly acting son, and ordered that he account for all of the transactions that he had made as the mother's attorney. And we'll get into accounting as attorneys more as this presentation goes on, but briefly, in accounting, when an attorney is ordered to account, it's almost like an audit of all of the attorney's transactions and steps that they've taken with the grantor's assets in their actions as attorney. And so the court in this McMaster case not only ordered that the son be removed as the power of attorney and that he account for all of his actions, but also ordered the son to pay $25,000 in legal costs to the mother and the son that had realized his improper actions after they had found that the attorney's son had acted completely improperly. This McMaster case is a perfect example of why, while the power of attorney can be a very valuable tool and resource for an older adult to appoint someone to act on their behalf, you have to be so careful in choosing who you do appoint, because it's a tool, and Kim and I in our office see this all the time. It's a tool that can be used to financially abuse and take advantage of the grantor, because it does provide such a broad power to the attorney who's acting. So it's very important to consider very carefully who you are appointing as your attorney. Here are some questions that you should be asking, and Kim was going through this as she was concluding her presentation, to determine whether or not you're appointing the right person. Is this proposed person willing to discuss your personal care issues and your preferences? And do they understand your goals and your values and your beliefs? Is this someone who you have an open and transparent relationship with? Someone that you trust to act in your best interests, not only while you are capable, but also when you lose your capacity? Will they be able to step into your shoes and make the decisions that you would otherwise make if you were capable of doing so? It's very important that the person that you do appoint as your attorney is able to ask difficult questions and make difficult decisions on your behalf, both financially and related to personal care. Is this a person that you trust to confront professionals, whether those be financial or medical professionals, to ensure that your assets are being protected and your personal care interests are being properly looked after? Most importantly, as Kim mentioned, is the fact that you have to be able to trust this person wholeheartedly and trust that they'll continue to act honestly and in good faith and in your best interests, and that they'll continue to put your interests in front of theirs so long as they're your attorney. You want to make sure, specifically in our experience, that this person has a good relationship with other supportive family members or loved ones in your life, so that they are able to coordinate and deal with those people as they're carrying out their duties as your attorney. So a lot of the time we see problems arise when powers of attorney are granted to a family member that may have conflict with other members of the family. And that can lead to further and greater conflict down the line when that person hides their transactions or isn't as transparent as they should be with the family members that would otherwise be supporting the grantor because of some underlying conflict. So it's important to choose someone as your attorney who you not only have a good relationship with, but has a good relationship with others in your life, your supportive friends and loved ones who you want to be involved in your care and in your life going forward. Now, it's important to choose this type of person when you're appointing your attorney, because an attorney is under statutory guidelines in carrying out their duties, and they assume a fiduciary obligation when they're appointed as your attorney, and that obligation is set out in the Substitute Decisions Act, or the SDA as I'll be referring to it. The SDA sets out all of the obligations and duties of a power of attorney, and it also includes the court processes for holding that attorney accountable, such as having that attorney pass their accounts, or as I was discussing before. Most importantly, and this is set out right at Section 32 of the Substitute Decisions Act, is that an attorney is a fiduciary. Their powers and their duties must be performed diligently, honestly, with integrity and in good faith, and at all times for the benefit of the grantor. And so whether you're acting as an attorney or whether you've granted that power to someone else, the one rule that should be front of mind at all times is that that person has to act in the best interests of the grantor, and with their goals and with their preferences at top of mind. So now I'm going to go through some do's and don'ts for an attorney. The first one listed on the PowerPoint slide there is to stay within the scope of the authority granted. And for that, the first thing that an attorney should do is look right at the instrument that's granted this power. So the power of attorney document itself. And in that document, it will note whether the powers are limited in any way or confined to a certain task that's been given to the attorney, or whether the powers are more general. And for an attorney acting on behalf of a grantor, it's crucially important that that their actions are confined to the powers that have actually been given, because they could be found liable if their transactions or if what they do on behalf of the grantor steps outside of that specific scope that's been set out in the power of attorney document. Now, a lot of the time we also see these powers of attorney that convey general powers more broadly, and in those circumstances, the attorney will have the power to do anything on the grantor's behalf that the grantor would have been able to do, except for make a will or make another testamentary designation, which we'll get into further later. This is the second point here is sort of along the similar lines as the first one, which is that an attorney should cease to act as soon as their powers are revoked or upon the death of the grantor. So it's very important, again, that the attorney act within the scope of their mandate, and that mandate will be set out in the power of attorney document, and the mandate will come to a halt as soon as that power is revoked by the grantor or by a court, or when the grantor dies, at which time the attorney's authority will immediately cease. Again, the third point is something that I've already addressed, which is that the grantor's comfort, well-being, and interest should be the number one priority for an attorney when they're acting. So always make sure that the decisions that the attorneys are making are to advance the grantor's best interests. Do not make secret profits. This is a pretty obvious one. The power of attorney should not act for their own personal gain or their personal benefit, and they should at all times make sure that their transactions are transparent and that nothing is kept secret from the grantor. The third point on this slide is something that we run into quite a bit in our practice, which is attorneys placing assets into joint ownership or commingling their own personal assets with the assets of the grantor. This is something that's done more often than you'd think by attorneys for the purposes of convenience or for planning purposes. But in the normal course, we would advise that the attorney not commingle their assets or put assets into joint with the grantor. And one of the main reasons for this is that if the attorney is asked to account or explain the transactions that they've undertaken since being appointed as attorney, it's much more complicated and problematic to do this if assets have been commingled or mixed with the grantor's assets. So it's best to keep the grantor's assets and the attorney's assets as separate as possible. It's very important that an attorney manage a grantor's property in a manner that's consistent with the decisions that are concerning that grantor's personal care. The financial decisions that are made on behalf of the grantor should always be made with the personal care decisions and the personal care circumstance of the grantor in mind. And if the power of attorney for property who's making the financial decisions for the grantor is not the same person as the power of attorney for personal care who makes the personal care decisions for the grantor, if those two are not the same person, they should still be trying their best to act in coordination with one another to make sure, for example, that there are enough funds available to provide for the personal care of the grantor, and to make sure that the financial decisions that are being made accord to the personal care decisions that are being made, and that those two paths of decision making happen in lockstep with one another and don't contradict each other. Another duty that's actually expressly set out in the Substitute Decisions Act is that an attorney must explain to the grantor the duties of the attorney and actually encourage the grantor's participation in the attorney's decision-making process. And that's a requirement that's actually spelled out explicitly in Section 32 of the Substitute Decisions Act. This third point on the dues section on this slide is very important as well. And it's also a requirement that's set out directly in the legislation, which is that an attorney is required to foster relationships, to encourage the relationships between the grantor and supportive friends or family of the grantor. So it's important that the attorney actively takes steps to make sure that the grantor of the power of attorney maintains those relationships with their loved ones, with their supportive friends and family that are around the grantor to provide that support. And it's actually a positive obligation on the attorney to make sure that those relationships are sedulously fostered. Don't sub-delegate responsibility as an attorney. Now, this is a little bit of a complicated point because depending on the complexity of the mandate that's given to you as attorney, sometimes it may be necessary actually for you to sub-delegate your authority, for you to ask professional advisors, whether those be tax advisors or lawyers or other financial advisors or healthcare advisors or professionals for advice on how to manage the grantor's property or personal care. But it's also important for the attorney to keep in mind not to delegate those decisions unnecessarily, because at the end of the day, the decisions that are made on behalf of the grantor fall on the attorney's shoulders. And it's no excuse for the attorney to say that they made decisions because of advice they received from the outside and therefore shouldn't be held liable. The buck really does stop with the attorney. And so they have to be very careful to delegate as necessary, but to still be the ones making the decisions at the end of the day. The second point on the do not here on this slide is also very crucial. It's do not attempt to change the donor's will or to change any other testamentary designations like the donor may have made in a designated RRSP or life insurance plan. Section 7 of the Substitute Decisions Act is very clear that a power of attorney for property has all of the powers that the grantor has and can make any transactions that the grantor would be able to make if they were capable of making them, except for make a will or make any testamentary designations or gifts on behalf of the grantor. So that's very clearly set out in the legislation that the one specific financial power that a power of attorney for property would not have is the power to make a will. The third point on this do not section is don't take any fees or compensation if the power of attorney prohibits taking such compensation. So obviously, if the instrument instructs you not to take compensation, the attorney won't do that. Moving on to the next slide here. Again, the attorney should consult with relatives, friends, and other attorneys on behalf of the grantor. That gets back to the point I was making before about fostering those relationships between the grantor and supportive friends and family. Keep a detailed record and keep detailed accounts of all transactions involving property. This is not only useful for organizational purposes for the attorney, but it's also going to be crucial if the attorney is ever required to account for their transactions. It will be of the utmost importance that the attorney has a complete and detailed list of accounts and records noting all the transactions they've undertaken as attorney, so that if they're ever called to account, they're ready to produce those records and show exactly what's been done during their tenure as attorney. The attorney has to exercise reasonable care and skill. And what does that mean exactly? Well, this is the standard of care that's going to be applied to the attorney's actions. So, and the standard of care that's applied will vary depending on whether or not the attorney is taking compensation for their role as attorney. A power of attorney who's not receiving compensation for managing the property of the grantor is expected to exercise the degree of care, diligence, and skill that a person of ordinary prudence would exercise in the conduct of his own affairs. Whereas the standard of care, if the attorney is taking compensation, is higher. And in that circumstance, the attorney is expected to exercise the care and diligence of a person who's actually in the business of managing property. So this is an important note for anyone acting as an attorney. If you're actively taking compensation or being paid for your duty and the work that you do as an attorney, the expectations are going to be higher. The standard of care that's you're expected to live up to is higher if you're taking compensation than if you aren't. If you're taking compensation, you're expected to have the degree of skill as a professional, whereas if you're not, the degree of skill that's expected is just as an ordinary person. Don't disclose information contained in the grantor's accounts and records unnecessarily. As the attorney, you're required to maintain the privacy and confidentiality of the grantor. But again, this is a balancing act because you're also expected to foster the relationships between the grantor and their family members and supportive loved ones. So to some extent, you may be required to disclose information about the grantor to those people to keep them in the loop and keep them apprised of the care that's being provided for the grantor or the decisions that are being made on behalf of the grantor. So this is a delicate balance that the attorney will have to walk between keeping loved ones involved in the grantor's life, but also maintaining the grantor's privacy and confidentiality as they would expect. These are some more dues for the attorneys in acting in their role as POA. They're required by Section 33 of the Substitute Decisions Act to determine whether the grantor has a will or not. And if they do, then any assets that are specifically gifted under that will are not to be sold or distributed by the attorney during the grantor's life, unless it's required to be sold or distributed to provide for the grantor either financially or on the personal care side. The attorney, as I mentioned, they must formally pass their accounts if they're required to do so, either by a court order or at the request of the grantor. And again, if it ever comes to a time where the attorney is asked to pass their accounts, it will be crucial that that person has kept a detailed list of all of the records and transactions setting out what they've done as the attorney. It'll make their life a lot easier if they're ever called to account for those transactions. It's also very important that the attorney keep a copy of the power of attorney document with them and easily accessible so that when they're carrying out transactions on behalf of the grantor, they have that document there if they ever need to prove their authority as the attorney, whether it be to financial institutions or healthcare providers. They are someone who has the authority to act on behalf of the grantor. I think that we're a couple of slides ahead here, Rayanne. Thanks. Okay, so I think one more slide ahead. So yes, the attorney should seek the professional advice of professionals when needed. So again, this gets back to the point about delegating authority and decision-making for the attorney. Of course, if you're dealing with complex matters, the attorney is expected to seek out professional advice as needed. But again, the decision-making at the end of the day, the buck stops with the attorney. The attorney should respect the donor's confidentiality. This was something I've already discussed, that the donor's privacy and confidential concerns must be fostered by the attorney. But at the same time, that has to be balanced with fostering relationships that the grantor had with supportive friends and family. These last few points are as pertain to decisions that are made in regards to the grantor's personal care. The attorney should always act in accordance with the known wishes or instructions that the grantor has provided as it relates to the personal care or medical decisions that are being made on behalf of the grantor. And the attorney should make decisions which are the least restrictive and the least intrusive on the grantor when they're making decisions in regards to the care that's being provided as attorney. So we have gone over some of the do's and don'ts for an attorney. But what about what a grantor or their relatives can do when it's expected that an attorney has failed in their duties or has abused the power of attorney? Well, now we're going to go over some of the remedies that can be used to address circumstances where attorneys have breached their fiduciary duty or have acted outside of the scope of the power of attorney that's been granted. And we're going to go over both criminal and civil remedies that are available to address abuses of the power of attorney or elder abuse in general. So first, I want to go over some of the differences between the civil and criminal remedies that are available. The number one difference is that while civil proceedings are between private individuals, so it's one private person suing another, criminal proceedings are between the Crown or the government and an accused. And so while anyone can start civil proceedings, it's only the government that can initiate criminal proceedings and bring charges criminally. But while anyone can start a claim under civil proceedings, there are still many barriers to private individuals in bringing those proceedings forward. Firstly, it's the cost of those proceedings. Oftentimes we see that access to civil proceedings are only available to those with the financial means to access them. It's a very expensive process and it's a very time-consuming process. And that could have the effect of prohibiting people from accessing the civil system if they don't have the financial means to do so. Meanwhile, criminal proceedings are of course funded by the government, who has unlimited financial resources and may be better equipped to bring some of those claims forward. Another important difference to note between the civil and criminal remedies available are the goals and objectives that are behind each of those remedies. On the civil side, the goal is restitution or repayment. The objective here is to put the victim back into the place they would have been had the wrongful act not happened or never happened, to return the victimized party back into their original position. So that could involve the perpetrator or the wrongdoer paying damages back to the victim or paying monies back to make up for funds that have been dealt with inappropriately. But while the goal in civil proceedings is that restitutionary goal, the goal in criminal proceedings is one of incarceration and punishment. And so criminal objective is more to punish the wrongdoer as opposed to making the victim whole, which is the goal of civil proceedings. The last difference noted here on this slide is there are different burdens of proof when you're talking about civil versus criminal proceedings. In civil proceedings, in order to succeed, the party must prove on a balance of probabilities, meaning it was more likely than not that the alleged wrongdoer actually committed the act that they're being accused of. This is a lower threshold to meet than the standard of proof in the criminal proceedings, which is beyond a reasonable doubt. And that means that to succeed in charging someone with a criminal charge, you must show that it's almost a near certainty, beyond any reasonable doubt, that the wrongful act actually took place. So these are all things to consider when you're determining how best to address instances where you suspect that elder abuse has took place. Obviously, the evidence that you'll need to prove that these things happen and to succeed in court is going to be different depending on whether a civil suit is pursued or whether remedy is pursued under an avenue that's provided for in criminal law. So I'm going to go through now some of the different types of remedies that are available civilly. You can apply to court to have the attorney removed for breaching their duties as the power of attorney, you can, again, apply to court if you suspect that the attorney has acted improperly in dealing with the funds of the grantor. You can apply to court for an order that that attorney account, or that they produce evidence as to how that money's been spent. And if it's determined that the money's been used improperly, or if the accounting shows that the attorney has absconded with funds or stolen funds, the court can then order that those monies be repaid either to the grantor or to their estate, or to wherever those funds ought to have gone. Another civil remedy that's available to the courts is that they can set aside transfers that have taken place. So what we see quite often is that older adults may transfer their real property into joint tenancy with their adult children. Sometimes this can be for planning purposes. This could be for the purposes of convenience of managing those properties while the grantor is alive. But something that many people don't realize is that when you transfer those properties into joint tenancy, something called a right of survivorship arises, which means that when one of the joint title holders passes away, the other title holder that survives inherits that property outright. And so this is where we often run into troubles, where an older person may transfer a bank account or a piece of real property into joint tenancy with, let's say, one of their kids, and they do so for the purposes of estate administration planning or for management purposes while they're living. But then when the elder adult passes away, that property vests entirely in the other joint holder, when that may have not been the intention of the original grantor or of the older person. In those cases, a remedy that's available and that a court can order is that the transaction to place the property into joint or to transfer the property to the third party can be set aside if it's found that it wasn't the grantor's intention to gift that property to the third party. Some other remedies that are available in civil suits are restitution through unjust enrichment, constructive trust, or resulting trust. So, for example, this gets back to the situation of property being placed into joint with a child or another party by the older adult. If a court reviews that transaction and finds that it was not the older adult's intention to actually gift that property to the person who they were transferring it to, the court can order that any interest that that person held in that property was only a legal interest and not a beneficial interest, and that the actual beneficial owner was the elder adult who transferred the property in the first place, and that they can vest title to the property back into the elder adult by determining that it was held on a resulting trust for them. At the conclusion of a civil proceeding, the court also has the ability to order damages or costs against the unsuccessful party. So those can include a portion or all of the legal costs that were incurred in the proceeding, but those decisions are entirely within the discretion of the court. So this next slide.
Sorry, Daniel.
Yes.
I'm just going to I'm just looking at time, and I'm wondering if we just take a stop. I think we have about 10 minutes left or so. I just wonder if we could ask Kim to join us and maybe just take a few questions that people had. The slide deck will be available after the session, so information that we didn't maybe get to specifically, people will still have access to, but I know there's a lot of questions that people want. So if that's okay with you, maybe I'll just kind of go through a few of the questions that have come up. The first one was, could the POA document for property be left with the bank?
Interesting question. The POA for property could be left with the bank. Often when you file the POA with the bank, or give it to the bank, it goes to their legal department to determine whether or not they're prepared to rely on it. Sometimes there are notes placed on so that when somebody goes to the teller, they can bring up the notes. The difficulty is keeping track of it, I would say, because there is, a turnover of staff and tellers and persons that look after an individual's account. So the continuity might not be what you expect. It may get missed. So if your intention on filing it with the bank is that it always be seen and there be no room for error, that's not always going to play out the way you think. So, so the answer is yes and no.
Another question just in relating to banks was, does one need a power of attorney for property to be a signature on a bank account? And when the bank requires a POA for property, does it cancel out another POA?
Right, so just to make sure I know what we're talking about here, there are power of attorney documents that are designed to deal with all of a person's property. That's a continuing power of attorney for property. Sometimes the bank and the individual or the individual client account holder will do a banking power of attorney. And it may just be over a certain account. And they cause issues because whereas the attorney appointed under the power of attorney document has global authority of all of the accounts, if this particular joint account holder or power of attorney over this one account is not the same person, issues can arise as a result of that. Sorry, the first part of that question, Rianne, was it about a joint account? I can't remember.
Yeah, if the attorney has to add themselves onto the accounts, but if they're the attorney, they have access to it anyway.
Right. They're the attorney, they have access to it anyway. They would best practices would not be to add yourself as an account, as a joint account holder or on the account, but rather that there be a note that the account is under power of attorney, but the account remains in the name of the person, the grantor of the power of attorney document. Was that clear?
Yep, I think so.
Okay.
So there were some questions about if you should have one or more attorneys. That was a general question that was asked.
Okay, so it's all dependent on your own unique situation and who you have in your life that you can trust. There is no better or worse. It's really unique to the person. I would say that if you had more than one, so let's say two, you know, it may be a check and balance on the other, but you would want to make sure you understood the terms of the appointment. So is the appointment to be truly joint? In other words, those two persons or three persons, as the case may be, always act together? Or is it joint in several so that they can act together but they could act alone? Or if it's truly joint and let's say it's three people, is there a decision-making or majority clause that permits two of the three to act in a certain way? And whether or not there's a mechanism within the document to iron out those potential disputes that may arise as a result. I think that as a matter of generally speaking, the situation where you appoint attorneys jointly and severally is difficult. Why I think that is because truly as a fiduciary, you are accountable to the grantor of the document. And if you have someone who's acting severally and not jointly with you, how do you keep track of that? It would be fine if the two had, they come up with a protocol and they trust one another and they agree that every decision is joint, even if one affects it as opposed to the both of them. But you really do run the risk of one person acting severally to the exclusion of the joint appointee, grantee, and then you lose the ability to insist on the accountability of the both of them. So There's no straightforward answer. It has to be tailored to a person's unique situation and circumstances.
So this next question kind of relates to issues around sort of COVID, but in a long-term care setting. When a client has dementia and has no insight, but is continuously buying things online, getting scammed, doesn't really have an understanding of the risks and the huge debts or unpaid bills, what can the family members be able to do? If the father or the dad, husband, doesn't give permission for them to manage their finances on his behalf, what steps can a family member pursue to keep the dad safe?
Right. So this is a situation with respect to property management. So it would only fall to an attorney or a guardian if there is one. If there is no power of attorney document, which is your scenario, right, Rianne?
Yes.
There's no, okay.
Yeah, it doesn't say, there was no mention of a POA.
Okay. If there's no POA and the family members believe that dad is incapable of managing his property, best practices would be to get some sort of an assessment through the LHIN or privately, or an assessment of capacity to manage property. And if truly the person doesn't have capacity, then the family can apply for a guardianship appointment. Alternatively, there is the ability where there is no power of attorney in existence and there is no interest in making a guardianship application, to have what's called a Section 16 assessment arranged for under the Substitute Decisions Act, whereupon a finding of incapacity to manage property would mean that the public guardian and trustee would be the appointed statutory guardian. Now, family members can apply to take over a statutory guardianship to the public guardian and trustee directly. So it is all based on capacity. Remember, I said that an older adult, like anyone else, is entitled to be foolish with their money, and if capable, can be foolish. If not capable, yes, the delicate balancing act of protecting and fostering the autonomy of the individual. So
one of the questions that's come up is around how do people get a capacity assessment during the time of COVID and social isolation?
Yeah, that's a good question. And so I understand that some assessors are doing remote capacity assessments. And obviously they have worked out a mechanism to get whatever medical records that they need in doing that assessment and getting authority or direction to talk to whoever it is that they feel they need information from to make an assessment happen. I know of assessors, I don't want to name them on I think you have to go to the Ministry of the Attorney General website for the list of capacity assessors, but there are ones who are doing remote assessments. And I understand where appropriate, you know, the LHINs make assessment in the circumstances that are appropriate in that context as well.
Okay. There's a question, what happens when the person who is completing a POA virtually is living with dementia, and when the POA needs to be redone, as it is temporary, the person's dementia has progressed in a way that the person can't remember the reason they chose the person they did initially, who will they be left without a POA?
So I understand you to be saying a power of attorney is done during COVID?
Right. And then their dementia progresses and they don't remember or recall. Will they be left without a power of attorney after that temporary time period is over, based on what the legislation indicates?
No. So if it's done properly in compliance with the emergency order in council, that document is a subsisting document. If it is a continuing power of attorney for done properly during the pandemic, compliant with the emergency order, it will continue. I may have confused whoever asked that question. What I was saying was it may be best practices afterwards to go back and revisit any document done during the pandemic especially if it's thought that there may be a litigious situation arising or predicted for the future.
Thank you. There's a question I know that I often get as well is, how does a power of attorney for property allow an attorney to remove someone from an elderly person's home? Should I get my name put on the property as a second owner?
The answer is not straightforward, but one thing is clear. No, you don't place yourself as an owner on the incapable person's property, because in reality, there's no beneficial ownership in that situation. So it is really of no consequence. So if there is a person living, you have to, I'm going to say it's a difficult, complicated situation. You would need to discuss a remedy. You could ask the person to leave. You want to look at how long has the person been there? And when the person whose house is being used, at the time that they went to live there, was the person capable? Did the person whose house it is make a capable decision to have that person live there? And then why are you trying to change the status quo? If there was a conscientious decision to allow that person to live there, why would you be seeking to terminate it? If it's an abusive situation, that's a different story. And of course, we do deal with those abusive situations, and we employ all sorts of resources, including reporting to the Public Guardian and Trustee Investigation Unit, or to the Vulnerable Persons Unit of the police in Toronto. That's the Toronto Police, the Vulnerable Persons Unit, but as appropriate given the jurisdiction of the person. And you know, it depends on what's happening, right? And you can, of course, get court orders, but it depends on all of the circumstances.
There's another question in regards to sorry, there's so many questions still. Sometimes agencies will get notice of abuse of power of attorney after sort of financial misuse has happened. So the client's banking institution has overlooked what is happening, unless amounts removed unless amounts removed from account were very much higher than normal. How do they address that? Or can you address that issue? So they're kind of getting notice of the abuse of power of attorney, but the bank sort of overlooked the issue that was going on. Is there anything that they can do about that?
So the question is the financial institution at fault? Is that what's really being asked here?
Yeah, it's sort of like how can they address that issue if the banking institution has overlooked what has been happening?
Okay, so banks wouldn't willingly, I would suggest, overlook what has been happening. They, quite frankly, might not notice. So if they notice, great, and they have their own internal guidelines that they've set up to deal with these situations. And that may include consulting with their client, the account holder, and if not satisfied, looking to whether or not there is any sort of capacity assessment, or quite what the findings are, or investigate around who this attorney is and what's happening. They are, of course, they use as a remedy all the time to freeze accounts, but holding the bank accountable would be dependent on what notice they had. And so if I were aware of an abuse, I would take it upon myself to notify the bank to look out for this issue. And if the situation is that the bank then decided to ignore my request to look out for the situation, then there may be some question of liability to be pursued against a financial institution. But again, it would depend on the circumstances. And so I'm hesitant to give an answer there where it's really circumstance specific.
Okay. Just a couple more questions. I think we're a little bit over time already, but one question just says, I have a power of attorney for my father for finances, who I feel is not doing their fiduciary duties as it pertains to his finances. I have placed him in, he was placed into dementia care last year, and his home sits empty when could be collecting rent in order to carry out expenses. Is there anything that that person can do to
Right.
alleviate that?
Again, it would depend on the circumstances, who this person is in relation to the person whose asset isn't being properly managed. So, and the reasons why. Sometimes on the face of it, for example, if there's a property and it's sitting empty because somebody's gone into a long-term care facility, what another might not know is that the will of the person actually directs, after their demise, that the property go to a specific entity or person, and so in that way it's being preserved. So you don't really quite know if there is mismanagement. If it's a person who would be of a relationship of sufficiency to ask, or if there was really some evidence of mismanagement, then that person could ask for leave of the court to require the fiduciary to pass their accounts before court and to account for the management of that asset.
Thank you. Here's another question. So what if a POA passes away and the other person who shares POA is incapacitated or is not mentally inclined? Can the active person, before passing, assign a POA to someone else in the family to act as a POA in the situation?
No. Although I have seen documents drafted to try to delegate that authority, and that's a trickier question, because if the grantors put their mind to that issue, can it be done? I'm going to say maybe, under the act, it's clear that it is only the person that can give the authority to another. But if there is a provision in the document itself, I think you have to look at that standalone and decide. But the short answer is no, you can't delegate. If the person passes away and the surviving attorney is incapable, the person doesn't have a power of attorney document, guardianship is an opportunity. It's an appointment of last resort. So for example, if it were with respect to personal care, you might look to the Healthcare Consent Act to see who else can make personal care decisions. If it's with respect to property, then you might have to look at statutory guardianship or an actual guardianship appointment by the court.
Okay, just conscious of the time. I'm just wondering, I know there's lots of questions that have come up, and I will do another summary and send them to both Kimberly and Daniel to see if they can give some responses. And if your name's been identified, I'll try to get some answers for you. Before we wrap up, I just want to give both Kimberly and Daniel an opportunity to just talk about some of the resources, because the information they presented here, they have done a lot of work in promoting or developing materials to educate the community on these legislation and complicated sometimes cases, but very general language that everyone can kind of understand. So can you maybe just highlight some of those key resources that you have?
Sure. Go ahead, Daniel.
Yeah, so all of our resources are actually publicly available and can be downloaded for free on our website. You just have to go to wellpartners.com/resources, and the various books and publications that we've come out with over the years are all there for downloading in PDF format. So those include books on powers of attorney and on fiduciary accounting, and our most recent publication, which is an elder law book, which covers all different areas that pertain to elder law. That was just published earlier this year. And in that elder law book, actually, I believe it's chapter 17, and Rianne, you have a copy of it right there. It lists a whole bunch of resources that readers can refer to in seeking assistance, whether that be legal advice or any other guidelines when it comes to addressing potential elder abuse. So all of those resources are up there on our website, and anyone's free to download them.
So the other thing I wanted to mention, and Rianne I think you have this resource posted, and I have it hosted on my website as well, and every once in a while I put it out on social media, are these two wonderful brochures that were put together by a consultative committee and the Toronto Police. And one is on the social isolation of seniors, an excellent resource, and the other is on elder abuse and neglect. And you'll find those on our website as well.
So thank you so much for bringing that up, Kim. I will, after the presentation, I'll make the PowerPoint available because I know that's been asked, and also the audio, but I'll also put links to some of these key resources underneath the webinar so people can access them, including the two documents from the Toronto Police Services and the coordinating committee that they've developed, because they are great resources. So on behalf of everybody, I would like to thank you so much for taking the time today to join us and share your information. I apologize for not being able to get through all the slides, but it just gives us the opportunity to have part B of this session as well, because I know there's so many questions that people still have around powers of attorney. So thank you again. Thank you all the attendees. Thank you for the ASL interpreters for joining us today. Again, if we didn't get an opportunity to answer your questions, we will try to follow up within the next week or so with you to try to give you some answers to your questions. So thank you so much for joining us.
Thank you.
Have a good day.
Thank you, Ryan.
Thanks.
Thank you.